At IIFL, where we offer customers a plethora of lending services, recovery of loans is almost as important as the process of lending itself, which makes arbitration a key part of our business. Meet Raj. He's taken a loan and has defaulted. Raj and the lender are both not keen on going to a court of law. They mutually decide to use Dev as their private judge, which makes him the arbitrator between them. So, what exactly is arbitration? Arbitration, in simple words, is an alternative form of dispute resolution. It is a process in which both parties mutually select one or more arbitrators, in this case Dev, whose decision remains absolute. Let's take a quick look at IIFL's 8-step arbitration process. Step 1. Identification of eligible cases. To initiate arbitration proceedings, only those cases which have 30 plus DPD and have a principal outstanding amount of 1 lakh or more are identified. Step 2. Loan recall notice. Once all cases are processed, a loan recall notice is sent to all the defaulters through an advocate, but this can also be done in-house if needed. Step 3. Intent letter. An intent letter is sent to an arbitrator to get his formal consent to act as the arbitrator for the case. Step 4. Disclosure letter. A disclosure letter is then sent by the arbitrator to both parties involved in the case. This letter confirms that the arbitrator has no past or present relationship with or interest in any of the parties of the case and has no relation to the subject matter of the dispute. This step ensures that the arbitrator is independent with regards to the proceedings and has no vested interest. Step 5. Reference letter. An in-house reference letter for the appointment of the arbitrator is issued to the arbitrator as well as the customer, notifying both that the matter has been referred to arbitration by the company. Step 6. First hearing. A hearing date and venue for appearance is set. On the first hearing or any time when the arbitrator permits, an interim application under Section 17 of the Act is filed for freezing of bank accounts and attachment of assets of the defaulter. Step 7. Second hearing. In case the customer does not appear in the first hearing or is represented by a pleader to contest the matter, a notice for a second hearing is issued by the arbitrator. Step 8. Third hearing. After the third hearing, evidence by way of an affidavit is filed and the arbitrator arranges to pass an award. Once the award is passed, the award is filed for execution on maturity of the 90 days cooling period. As part of another recovery procedure, let's look at the process of check bouncing cases. At the time of obtaining the loan, Raj had deposited post-dated checks for creating security in favor of IIFL. If Raj defaults on the payment of the loan, IIFL can deposit these checks in order to realize the amount in its favor. However, if the check is returned with the endorsement funds insufficient, the Negotiable Instruments Act 1881 comes into play. According to Section 138 of the Act, the dishonoring of a check is a criminal offence and is punishable by imprisonment of up to 2 years or with a monetary penalty, or both. Let's take a quick look at IIFL's 7-step check bounce procedure. Step 1. Identification of eligible cases. To initiate proceedings under Section 138 of Negotiable Instruments Act, only those cases which have 30 plus DPD and have a principal outstanding amount of 1 lakh or more are identified. The duly filled checks are then banked after due diligence for either the overdue amount or the foreclosure amount based on DPD. Step 2. Legal notice. A legal notice is issued to the drawer within 30 days of the dishonoring of a check, giving him an opportunity to make the payment within 15 days of the receipt of the notice. Step 3. If the payment is not made within 15 days, a complaint is filed against the drawer of the check within 30 days of the expiry of the 15 days specified in the notice. Step 4. Once the complaint is filed in the court and the court finds satisfactory grounds in the complaint, summons will be issued against the drawer of the check within 30 to 45 days. Step 5. If the customer abstains from appearing in the court even after the summons are issued, a bailable warrant will be issued against him. If the non-appearance continues, a non-bailable warrant shall be issued against the customer by the court. Step 6. The customer may secure his appearance in court during trial by furnishing a bail bond in the court. The matter then proceeds to the evidence and argument stage, where both parties can present the documents supporting their statements. Step 7. The court will proceed in delivering the judgment in the case according to the evidence presented and arguments made. The customer may also deposit the check amount before the court in favor of IIFL to settle the matter at any point during the proceedings. This is what financial arbitration and the process of check bouncing cases is all about. For any further clarifications on the arbitration process, please reach out to us on arbitration.team@iifl.com and legal.section@iifl.com. Welcome to IIFL. Best wishes and good luck.